In the previous section, we explored ownership structures that allow real property to transfer automatically to a surviving owner without probate, including joint tenancy with right of survivorship, JTW Ross, community property with right of survivorship, CPW Ross, and the beneficiary deed under ARS, paragraph 33, 405. These ownership forms streamline estate transfer and minimize the need for court intervention. However, when none of these probate-avoiding mechanisms exist, property must pass through probate court to determine who has the legal authority to sell or transfer ownership. Probate is the judicial process by which a deceased person's assets are inventoried, debts settled, and remaining property distributed to heirs or DVZs. For real estate professionals, it is vital to understand who has the legal standing, also called legal authority or capacity, to list and sell property that is subject to probate. Without proper authorization, any listing agreement or sales contract may be invalid and unenforceable. Understanding legal standing in probate property sales. When a property owner dies without a survivorship clause or beneficiary deed, title does not automatically pass to heirs. Instead, the estate must be administered through the probate process under Title 14 of the Arizona Revised Statutes, specifically ARS, paragraph 14, 3701, through paragraph 14, the 3715, which govern the powers and duties of a personal representative. Until a probate court appoints a personal representative, executor, or administrator, no one has the legal right to list, sell, or transfer the property. This means that even if surviving family members are named in the deceased's will, they cannot take any legal action regarding the property until the court formally grants authority through the issuance of letters of personal representative, letters testamentary, or letters of administration. These letters serve as legal proof that the person has the authority to act on behalf of the estate in managing, listing, or selling real property. Example scenario. Suppose John, a widowed homeowner in Tucson, passes away leaving a will that names his daughter, Sarah, as his sole heir. Sarah contacts a real estate agent to list her father's home immediately after his death. However, because the property is titled solely in John's name and no survivorship or beneficiary deed exists, the property must go through probate. Until Sarah is appointed by the probate court as personal representative, she has no authority to sign a listing agreement or contract for sale. The real estate agent must wait until the court issues letters testamentary confirming her appointment. Once those letters are issued, Sarah can legally act on behalf of the estate and authorize the listing. This process ensures that only individuals legally recognized by the court can sell or encumber estate property, protecting heirs, creditors, and potential buyers from disputes or fraudulent conveyances. Who can be appointed as personal representative? Under ARS, paragraph 14R3203, the order of priority for appointment as personal representative is as follows. The person named as executor in the will, the surviving spouse of the decedent, if they are a DVZ, other devisees, those named in the will, the surviving spouse, if not a DVZ, other heirs of the decedent, if none of the above apply, a creditor of the estate after 45 days from the date of death. The appointment process depends on whether the decedent left a will, testate, or died without one, intestate. Intestate estates, the court typically follows the decedent's wishes by appointing the person named in the will. In intestate estates, the court appoints an administrator according to statutory priority, authority, and limitations of the personal representative. Once appointed, the personal representative's powers are governed by ARS, paragraph 143711, and ARS, paragraph 143715. These powers include collecting and managing estate assets, paying debts, and distributing property. Importantly, they include the authority to sell or convey real property, either by private sale or public auction, if such sale benefits the estate. However, the personal representative's powers are not absolute. Certain transactions, particularly sales of real property, may require court approval, especially if the will does not grant independent authority or if objections arise from heirs. Therefore, real estate agents must ensure that a certified copy of the letters of personal representative is provided before entering into a listing agreement and must verify whether the sale requires additional court confirmation. Role of the real estate licensee in probate transactions. Real estate professionals must exercise caution when dealing with probate properties to ensure compliance with Commissioner's Rule R4.28.11101A, which requires licensees to act with honesty, competence, and diligence. Agents should confirm the seller's legal capacity by reviewing official probate documentation before proceeding. If a family member or heir attempts to list the property without authority, the agent should advise them that only the court-appointed personal representative can act. For instance, if multiple heirs contact a broker to list their late father's property, but none have been formally appointed, the broker should refrain from signing any listing agreement until proper documentation is produced. Doing otherwise could expose the broker to disciplinary action or civil liability for unauthorized practice. Case example: in Re Estate of Newman, Arizona Cia Apps 1991. In this case, the court held that a sale contract signed by a person who was not yet appointed as personal representative was voidable because they lacked authority at the time of signing. The court reaffirmed that legal standing must exist at the moment of contract formation, not afterward. This case serves as a reminder to real estate professionals and heirs alike that only court-appointed representatives may legally bind an estate in property transactions. Discussion: why is a family member not automatically authorized to sell a deceased relative's property? Answer: because legal authority to manage or sell estate property must be granted by the probate court through letters of personal representative. Without them, the individual has no standing. What document serves as proof that a person has legal standing to list or sell probate property? Answer: the letters of personal representative issued by the probate court confirm the individual's authority to act on behalf of the estate. Under what conditions might court approval be required for a personal representative to sell real property? Answer: when the will does not grant independent authority, when objections are filed by heirs, or when required under probate rules to ensure the sale benefits the estate. Review summary: when property must go through probate, only a court-appointed personal representative has the legal standing to list, market, or sell the property. This authority is granted through letters testamentary, when there is a will, or letters of administration, when there is no will, issued under ARS, paragraph 14, 3701 ASECU. Family members, heirs, or devasees have no power to act until officially appointed by the court. Real estate professionals must confirm this appointment before executing a listing agreement and should ensure all estate-related requirements, including possible court approvals, are satisfied. This protects the integrity of the transaction and prevents unauthorized conveyances. Arizona case law, such as in Re Estate of Newman, reinforces that contracts signed without proper authority are unenforceable.